Thank you. My name's Kevin McMahon and I'm the spokesperson, the present spokesperson for United Against Injustice. First of all, I'd like to thank all those who attended the workshops this morning. I thought they went very well indeed. There was a lot of very interesting questions that were put to people, and I think a lot of people got some answers. I was certainly kept very busy afterwards speaking to people. So busy, I couldn't, unfortunately, go to the workshop upstairs, which I believe was fascinating. Someone asked about polygraph tests. Well, I was approached by a senior polygraph examiner, Don Cargill. Is he in the room now? He is coming back later. And so if those people who asked about that particular subject, we had an expert in the room. A few housekeeping points, first of all. Then I'll tell you a little about myself. I'll tell you a little about UAI. And then I'll hand you over to Bruce Kent, who will introduce you to the speakers. You can see the list here. The speakers, we'll have a little break, and then some speakers later on. But I'll leave all that up to Bruce. Housekeeping points. Mobile phones off, please. As you should know, there will be no smoking indoors. Of course, you already know that. I have to point out to you the fire exits. There's one here, and there's one at the front door. And there's also first aid kits available at those two points. This afternoon's proceedings will be filmed. The film will be available for people to purchase later, and if you contact via the UAI website. Now, have I missed any housekeeping out, Demos? No. Right. Okay. Now, just tell you who I am. My name's Kevin McMahon. As I told you, I'm presently the spokesperson for United Against Injustice. I'm also the chair of Merseyside Against Injustice, which is one of the member groups. I'm a former Special Branch Officer of Merseyside Police, and prior to that, I was in the Special Investigation Branch, Royal Military Police. Since 1989, I've been involved in the world of miscarriages of justice. Involved in many television programs about it, assisting in cases all over the country of all different kinds, and I'm still inundated today with inquiries for help, which I'm happy to give if I have the available time. So that's who I am, and that's what I do. How I came to be involved in it is far too lengthy a story to involve you in, but safe to say that as a serving police officer, I reported the corrupt practices of senior police officers, so I didn't really stay in the police. Well, actually, I did, 4 years it took before they, eased me out. Well, let's put it that way. So I think I was quite tenacious to stay in that long. But anyway, I've been involved in miscarriages of justice ever since. But because I was asked on so many occasions to look at various cases, I formed Merseyside Against Injustice in the area, of course, where I live, in Liverpool. And along the way, I met Barbara Stone, the sister of Michael Stone. And with a little conversations with her and some encouragement, Barbara formed Kent Against Injustice. And so already formed at that stage was Innocence, a Manchester-based group. And there were various other miscarriage of justice groups throughout the country and others that spring up from time to time. And part of what UAI does, and UAI, which is the meeting you're attending today, United Against Injustice, is the umbrella group that brings all those miscarriage of justice groups together. And some time back, the idea of this came to my mind, and I had a word with Barbara and said, what do you think? And we were at a meeting at the time, and Andrew and Anne were there from Innocence, so we got together and we thought, yes, we'll try and get this off the ground. And that's really how United Against Injustice was formed. Now, United Against Injustice is not themselves a campaigning group. It's a group that brings together, an umbrella group, if you like, that brings together the other groups. Now, those other groups, they have their own particular agenda, their own set of cases that they're looking after. And we facilitate the bringing together. And our two principal ways in which we do that are by the maintenance of a website, and if that website workshop we've had today is anything to go by, our website is going to be dramatically improved. So that's an excellent source of information. And the other source of information, of course, is our annual meeting. And the 11th of October is National Miscarriage of Justice Day, so we hold it fairly close to that day as we can, and that's why we're here today. And one of the principles we adhere to, and you'll hear this, I hope, reinforced time and time and time again, is that we try to empower people to take control of their own particular cases. And we talked about, for those who were here this morning, you know exactly what we mean by that. You don't hand it all over to your solicitor and say, just get on with it, however competent he might be. You need to keep control of that case. And you can keep control by making informed decisions. And you make those by getting knowledge. Knowledge is your power to do that. And you get that knowledge by meeting people here today. Now, there's a whole new lot of knowledge on this floor that we don't yet know, because there's a lot of new people here, and we want those people to speak up. We want them to ask questions later in the question and answer time, and that knowledge will find its way to other groups throughout the country through the system and onto our website. That's how it works. I think that's about all I need to say about how we work and why we're here. So I'll now hand you over to Bruce Kent, who will introduce each guest speaker. Thank you very much.
Thank you very much, Karen. Well, thank you everybody for coming. It's my job is to make sure that we run to the timetable. It's quite tight. The first three speakers have got 20 minutes each, and then we have a break at 3:10, and so we'll go straight into that. There is going to be a slot at the end of the day for questions and answers, so everybody be involved. I know that Mark has to rush off before that because he's got another conference to go to, but perhaps he'll stay during the break if he's free for that to talk. But if not, you can certainly mingle with the other speakers during the 3:10 break. That's quite enough from me. I would like to invite Mark Macdonald, who's a defence barrister and who has defended Mick Stone, a case you'll know all about. Mark, the floor is yours.
Thank you. What I want to talk about really are three things. The first is current proposals to the criminal justice system, what has already taken place, what is going to take place, and how that's going to increase, in my opinion, further miscarriages of justice. Secondly, talk briefly about the Michael Stone case. Many of the issues there will be familiar, I'm sure, to most of the people that are sitting here. And finally, to talk about the Innocence project, and of course Michael, who you're going to hear from later, who will expand on that. Right, first of all, the criminal justice system. Many of you will know that under our present government there's been a substantial reform in the criminal justice system. I call it reform, probably not the best word to use, but there's been a number of pieces of legislation which has dramatically affected the convictions in our courts over the last few years. Probably the main one has been previous convictions going before the jury. Now, under the Criminal Justice Act, it is a lot easier to get to get convictions before the jury. It used to be in the past, and indeed, it wasn't unknown that convictions did go before the jury. Primarily, if you attack the credibility of a prosecution witness, then your convictions were open. It used to be called the shield. I don't know if you remember that. Your shield used to go if you attacked the credibility of a prosecution witness. So if you said to the victim or the complainant, when you cross-examining as a barrister, you're a liar, you're making all this up, then you're open for your convictions, if you have any, to go before the jury. Well, now, actually, it's a lot easier, and those convictions can go before the jury, even if you don't attack the credibility. Those convictions can go before the jury, even if you don't give evidence, which means that right from the start, you're playing a game. And I use the term a game, but as a barrister, as a tactician, you've got to think and consider what is the effect of the previous convictions of your client going before the jury, and how is that going to affect the outcome of the trial? Because, you know, no jury in the world is going to ignore the fact that there are convictions there against you, and there are convictions that may be for a similar offence for which you're charged with today. And probably the core of our criminal justice system is that you're innocent until proven guilty. And one of the problems is that once your convictions go before, that core goes, that core is damaged. And people will look at you and say, well, look, he's done it before, therefore he's guilty of this one, and not look at the evidence. And as a result of that, what we're getting are more and more people being convicted on their history, on their past, and not upon the evidence that's before the jury at the time. And I think that's going to come back to haunt us in a few years' time. We're going to have many people that are in prison that simply should not be in prison. That's the first thing I wanted to mention. The second thing is this. Legal aid. There's a substantial cutback in proposals of legal aid in this country, which is going to cause hundreds, if not thousands, of solicitors' firms to effectively close down, and cause a lot more solicitors to leave legal aid and go into private practice, which will mean what? Well, first of all, it will mean that there will be substantially less clients at the bottom end of the level. So those that are arrested for shoplifting or arrested for drunken disorderly, which will not get a lawyer. And what's the consequence of that? They appear in a magistrate's court. They appear before a magistrate with no legal representative, no one to put their case before their hand, no understanding of the legal system, and they're being convicted, and they're being sent to prison without a lawyer being anywhere in the process because of government reforms and the legal aid system. But what else? Well, the other problem is that the idea is to get all the lawyers together to cut all the small firms. Now, the small firms, and this is how it's reflected upon ethnic minorities, because the small ethnic minority firms, and there's so much to discuss here, and I've got 20 minutes, so I'm trying to speed up, but the small firms, the ethnic minority firms, are generally smaller firms, which means that ethnic minority clients are going to suffer as a result of those firms closing down. It's quite a complex system, and I've only got a few minutes, but I'm highlighting the fact that legal aid reforms, legal aid proposals that are going to be coming in the next year are going to have a substantial effect upon legal representation of individuals in this country. And I think we all should be aware of that, and we should all start talking about our MPs, because it's going to be going through Parliament, and we all should start saying, hold on, what's going on here, and asking serious questions of our members of Parliament. Okay, I'll leave that to one side for a moment and just concentrate a bit more on Michael Stone. Michael Stone, as you know, many of you, was convicted, I think, 2001. On the second trial, there is no direct evidence against Michael Stone. And as I say, many of you will be familiar with what I'm about to say, not simply because of the Michael Stone case, but because I'm sure it rings many bells in the cases that you're here and concerned about as well. There is no direct evidence. There is no forensic evidence. There is no identification evidence. In effect, the only thing that keeps Michael Stone in prison is a self-confession. Self-confession, which when used in the Michael Stone case was a very rare form of evidence, but now is more and more often being used in trials. Self-confession of one individual for whom we have received evidence, was at the time that he heard, or alleged to have heard, the confession. And remember that the confession was heard in an adjoining cell through a pipe system that ran between the two cells. From listening to the pipes, the man who gave the evidence of that was addicted to heroin at the time and was mainlining at the time, and had been moved from the mainstream prison into the segregation unit. And then once he was able to give the evidence to the police officers, was moved back into the mainstream of the prison, and therefore his opportunity to get drugs was obviously greater. But that again, there's much more on Damien Daly. There's the fact that he has previous convictions. There's the fact that since giving that evidence, he has told people that he has shared cells with that he has lied. We went back to the Court of Appeal 2004. In 2004, when we went back to the Court of Appeal, we put all this before the judges. Judges said it wasn't enough. The Court of Appeal said no. You need more than simply this. So what happened, and this is where it goes on to the final thing that I'm going to talk about, and that's the project that Michael started in Bristol and has expanded across the country of the Innocence projects. I and some other people set up an Innocence project at the Intercourt School of Law. And it's different from the point of view that it's barrister-led. So we've got practitioners. I've got 27 barristers who are willing to do this work, and over 70 students who are all postgraduate training to be lawyers, who are picking up these cases. And we've now got there's about 10 cases that we're looking into. The students are supervised by barristers. They work as a team. As a consequence of the work, we've got leave on 2 cases, and we've had a conviction quashed 2 months ago on another case. We are making substantial progress on a number of cases, and we're able to, I think, as practitioners and as barristers, are able to progress things substantially. Now, the way we're doing it is this. We're doing it in a twofold way. The first is, if a person who is in prison, who is maintaining their innocence, says to us, hasn't been to the Court of Appeal, we're looking at it and we're drafting grounds of appeal to take them back. If they have been to the Court of Appeal, we're drafting applications to the Criminal Cases Review Commission. And very briefly, the Criminal Cases Review Commission are doing a fantastic job, but are overworked. They don't have the resources. And so this is where the Innocence projects are being able to feed and being able to help by drafting the applications to go to the CCRC. So it's a sort of twofold solution. The drafting of the application or the drafting of the Court of Appeal, depending upon what stage we're at. Who's sending us the cases? Well, of course, we've got the Innocence Network who are sending us the cases, but we've also got instructing solicitors who are contacting me and are sending the cases. From a financial point of view, we are doing it all pro bono. Anyone can come to us and we will work on the cases on a pro bono basis. If there is money there, we don't get paid. We say use that money to get transcripts, use that money to get rulings of certain decisions, use that money for forensic cases. So if there is any money in the pot, we use the money that way. The whole idea is that it's a pro bono setup there, and the primary objective is to ensure that any person who is in prison and maintains their innocence, we look at it right from the beginning. We go through every single element of the case, right from the moment that the defence solicitors who are representing them got the case to the moment that the judge or the verdict comes back by the jury. So, as I say, we're progressing substantially. We're doing quite a lot. I can see it's 20 past. How long have I got?
No, 10 minutes. 10 minutes.
Got loads more time.
You're done with yourself.
So we're progressing substantially on a number of cases. I'll give you an idea of how the Innocence Project has helped. In the Michael Stone case, going back to this self-confession, the witness, I've already mentioned his name, was a man called Damien Daly. He was, and I think some of you may know him already in here, I've been talking to Barbara earlier. He, as I said, had turned round to people in a cell and said, I lied. I made it all up to help the police. Now remember, of course, it was starting from the premise that this is the only evidence against Michael Stone. So we got one of the witnesses, one of the people that was sitting in the cell, and he made a statement, made quite a thorough statement of what had taken place in that cell and what he had heard from Damien Daly. And the trigger for this conversation was a television programme. Television programme which was on a news broadcast, and it was, they'd watched the news, and Michael Stone had come on the news, and they turned around to Damien Daly and they said, well, what's this all about? And Damien Daly turned around and said, I lied. So we gave the statement to the police. Within 48 hours of giving the statement to the police, this witness, who is now out of prison, was arrested. He was arrested on suspicion of burglary. This was all before the Court of Appeal on the last occasion. He was then taken to Belmarsh Prison, where he was interviewed about the statement that he had given to me 5 times. And what they had done, the police, is they'd gone away and they had collected every single news broadcast that had taken place during the period that they were in the cells. And they were able to turn around and say, there was no news broadcast. You're making all this up. So they're sitting in this cell, according to our witness. The news had come on, but there was no news broadcast. The police said Michael Stone was never on the news when you lot were sitting together. Totally undermined, obviously, this witness that we thought was a great witness for us. So then a couple of years went by. We lost, obviously, in the Court of Appeal. We went down the road, and the students came on board with the Innocence project. And I asked the students, 2 of the students, to go and look at this and to find out if it had actually taken place. And they did. And they looked at what the police had done and how they'd gathered this evidence, these news broadcasts. And they'd used a database. And the database had every single news broadcast on it, as the police had said, that had taken place over that period. But there was a fault, there was a flaw in those broadcasts, because it only showed new images. Any library picture that was on there was not on the database. So they thought, well, that's a bit odd. Well, we'd better go and have a look at every single news broadcast. So they went down to the archive system, which was in Wiltshire, the 2 students, and they sat and watched every single news broadcast over that period. Something had never been done before. And right in the middle, guess what, was a news broadcast of Michael Stone on the news. And of course this witness was right all the time. And that was found by the students. And that's the work that they're doing. And they're doing excellent work. And so that gives you an idea of the work that the projects are doing. And you're going to hear from Michael later, I'm sure he'll expand on them. But they're certainly doing some excellent work throughout the country. On other cases that we're dealing with at the moment, there's one case for which we've now got new evidence that has been discovered on a case of a nurse who was convicted. I don't know if you remember this case that took place about a year ago. He was convicted of 2 murders and 18 counts of grievous bodily harm. On that case, the students have been working on that now. I can see the parents are in the audience here today with us. On that case, they've been working on that now for many months. There was a tremendous amount of documents in that case, and as a result of that, the work that they've done, we've been able to get together grounds of appeal, and I'm glad to say that, and new evidence, we've now been able to submit grounds of appeal in that case. So tremendous work is being done. If anyone wants to seek my help or the help of the Innocence Project, I'm going to give you my email address. which is, it's my Chambers email address, mcd, that's Macdonald, mcd, at that's number 1, pumpcourt, all one word, .co.uk. And certainly I will then take your details and transfer on to the Intercourt School of Law, who will then process it from there.
Thank you very much, Mark. It all gets more and more astonishing, isn't it, really? I'd like to thank Mark very much for coming and speaking. I would now like to introduce Sandra Lean, and it's a pleasure for me to meet her because someone sent me a copy. I didn't know anything about her excellent book, which someone will know, I'm sure, No Smoke. And it's a number of cases, Sandra will tell you how many, just showing the incredible incompetence, mistakes, whatever has gone on in various cases and the assumptions made. So, Sandra, it's a great pleasure. Please use the microphone, and you have 20 minutes.
Thank you.
I think you do need a microphone.
What I wanted to speak about today is more the experience that I discovered in the various cases. The experience of people who find themselves in the system, if you like, at the very beginning. I was brought up to believe that if you've done nothing wrong, you've nothing to be afraid of. Yeah. And I brought my children up to believe the same thing. And like so many people in this room today, I discovered that nothing could be further from the truth. If you find yourself tangled up in the criminal justice system and you've done nothing wrong, you probably have everything to be afraid of, is the discovery that I made looking at the various cases that I covered in the book and people that I've spoken to since. This idea that because you've done nothing wrong, you know you've done nothing wrong, so you sit and wait for someone out there to go, oh, it's a huge mistake, you know, we can sort this out, and you know, you'll go home, it'll all be sorted out. While you're sitting there waiting for that to happen, the case is being constructed round about you, and you have no idea that that's what's happening. You're still sitting there, you know, oh, it'll be sorted, it'll be sorted. So you lose so many chances and so many opportunities in just that section. Things will seem odd, things will be said and that seem strange, but still you think, well, this will be sorted out because it's a mistake. And already, the wheels are in motion, already it's started to go in a particular direction. And there's some people who hold on to the idea that it's just a huge mistake, and because they've done nothing wrong, it'll be sorted out, right up until the point where the jury foreman stands up and says the word guilty. And at that point, facing 20 years for having done nothing wrong, the truth finally dawns. Nobody's coming to rescue you. Nobody's coming to save you. It's done, it's finished. And I wondered, well, how? How does this happen? It's like, you know, you watch your Derren Browns and your David Copperfields walking through the Great Wall of China, and you know it's an illusion. You know you're being tricked. How can we have this system that is an illusion, that we're all being tricked, and we just don't know it's happening? It's really, I found it really hard to accept. It's why I continued digging for bits and pieces to see if I could find some answers to that. And one of the things that people would say, well, I know my rights. I know, you know, what my rights are. And that's fine, that's good. But you need the system to obey the rules for you to exercise those rights. And it doesn't, a lot of the time. You need the system to be based on reason and logic and truth. And in several cases, it's not. So then you have these rights that you can do nothing with. For example, you're at the stage of helping the police with their inquiries. You haven't been charged with anything, you haven't been cautioned. You're simply telling the investigators what you know in the hope that it will lead them towards the person who's committed this dreadful crime. 5 hours later, you're still there. You've had nothing to eat or drink. You're exhausted. You're probably still in shock. And you're becoming increasingly confused because you're not quite sure why you're still there. You've told them everything you know, several times. You start to ask questions. Am I a suspect? I say, no, we need to get our facts straight here. And you say, well, do I need a solicitor? Should I have a solicitor? I haven't been charged with anything. And somewhere in the back of your mind, you remember something about, being entitled to a phone call or something. So you say, well, should I have a phone call? I'm entitled to a phone call. And I say, well, you've not been arrested. You won't get your phone call, but you've been pacified. You've not been arrested. And eventually, after either they've got enough for the time being or what have you, you'll be presented with a statement that a police officer has written out on your behalf to check it over and sign it as correct. This is what happened, this is what I said to the police officers, blah, blah, blah. And by this stage, you just want to go. You just want out of there. You've had enough. Glance over it. Looks like it covers pretty much what you've talked about. Half it you've forgotten anyway by this stage. Sign it. Seems harmless enough. In some cases, that's akin to signing your own death warrant. One story that I've never forgotten in the Luke Mitchell case, which was the very first case that I became interested in Scotland. The mother, Luke's mother, hadn't been kept informed while the search was taking place, so she didn't know that a body had been found, as far as she was aware. They were still looking for a live 14-year-old. And somewhere in the midst of all the passing of information, she said, "Jodie's dead." The statement came back, the written statement came back 7.5 hours later. They questioned them throughout the night after the body was found, and the statement came back for her to look over and sign. And the question mark was missing. So what we had was a statement of fact: Jodie's dead. A fact that she couldn't possibly have known at the time. So, the idea that you look over the witness statement and make sure that it's what it's supposed to be. Something as simple as a punctuation mark. And it changes the whole meaning. Which brings us to the why. Why is it necessary to pursue information in that manner? Why not just go after the truth? That would seem like the obvious thing to do, just go after what really happened. And that's where this illusion comes back in again, this idea that an investigation, as Joe, ordinary member of the public, before I started looking at these, this was my belief. The investigation is looking for the truth. It's looking to find the information that will lead to the person who committed the crime and bring them to book for it. But if you look at the fact that sometimes it's simply the case that the case needs to be closed, we need a conviction. And, well, somebody makes a decision somewhere that says, right, this is where we're going, this is what we believe happened. And at that point, what's looked at and what's gathered becomes selective. If it fits with the decision that that's what we're going to go for and that's who we're going to go after, then that information will be kept. And if it doesn't, well, it's not really relevant, is it? And that's the stage where, once these wheels are in motion, it becomes a bit like a runaway train. It's been pointed in the right direction, and the idea now is to keep it running in that direction. All the other trails go cold. Anything that doesn't keep it going in that particular direction, or may obstruct it or divert it off in another direction, it's just lost. It just goes very quiet. Other ways of making sure that the investigation or the whole thing continues to go in that particular direction. A quiet word in your local friendly media person's ear is usually quite a good way to keep it going. One of the cases that I looked at, there was a surprise raid, a raid with an element of surprise obviously, 7 o'clock in the morning. They were going to descend, this huge team of officers were going to descend on this house and take them all away and empty the house and take all the, search all the house and everything. Obviously the 7 a.m. being the surprise element. more than 20 reporters and photographers were camped outside by 6:45, so obviously the surprise element was lost on them. And I spoke to a few people about that. I said, you know, well, how do you think they knew? How do you think they knew to be there at that time in the morning, at that particular address? And bizarrely, some people actually said to me, and this is where you understand that there's an element of trust, blind trust. Journalists just know these things. I'm not sure which is more frightening, the idea that the police are, you know, giving out this sensitive and confidential information to the press, or the idea a bunch of journalists running around using their psychic powers to figure out what's happening next. Yeah. But once you're using the press, once you're using the media, black